Well, right as soon as we're getting ready in our comfortable chairs to watch the Donna Adelson trial that we've been waiting for so many months, counting down the days, we're ready to go. Jury selections that was supposed to begin today. We get a last-minute motion filed by none other than Charlie Adelson. That's right. Charlie Adelson's attorneys, his appellate attorneys, filed a motion into the Donna Adelson case. And now, because of this motion, this trial may not occur today. We will see. And this is a real problem. So let's go through this motion. We'll talk about the law like we always do. We'll analyze it, and then we'll see what eventually the judge is going to do in this case. So what happened? We have a day before the trial, literally the day, this was filed September 16th, 2024 at 11:18 a.m. And jury selection is supposed to begin September 17th. So less than 24 hours before jury selection is supposed to begin, we get this motion filed. And as you can imagine, one of the first questions that the judge asked at the hearing today was, why did you wait for the last minute? As you can imagine, he is not going to be happy with the fact that they waited for the last minute. However, they did have a good excuse for that, and that is that they didn't receive the subpoena for Charlie Adelson until literally a few days ago. So they quickly had to meet with Charlie Adelson, discuss what's going on, and then had to file these papers. So let's get into it. The motion says the following. Mr. Adelson, referring to Charlie Adelson, was previously charged in Leon County, as we all know, with first-degree murder, conspiracy to commit murder, and solicitation to commit murder. The case proceeded to trial, and Mr. Adelson was convicted as charged. As we know, Charlie Adelson was convicted. At trial, Mr. Adelson was represented by, we all know, Daniel Rashbaum, Esquire. So he was represented by Dan Rashbaum. And we all knew this. We've been hearing about this, that Dan Rashbaum is now representing Donna Adelson. And does that present some sort of conflict of interest? And we've spoken about this in previous videos. And of course, there is a conflict of interest. And Dan Rashbaum got a waiver from Donna Adelson to waive that conflict. And we'll see here that he actually did not get a waiver from Charlie Adelson to represent Donna Adelson. And normally, when you have a conflict between two parties, you've got to get a waiver from both parties. Now, in this case, it appears that he only got a waiver from Donna Adelson and not from Charlie Adelson. So right away, something a little bit off. Why didn't he get a waiver from Charlie Adelson? Maybe you just assumed that Charlie Adelson is not going to be called in the case. Nevertheless, it would have been prudent for him to definitely get a waiver from both parties before representing Donna Adelson. Now, we spoke also about, even if you get the waivers from Donna Adelson, you get the waivers from Charlie Adelson, is it still a good idea for Dan Rashbaum to represent Donna Adelson, even with the waivers? And I've always maintained that that was a poor decision. It's not a good idea for the same attorney who argued everything that he argued in Charlie Adelson's case, and he's kind of locked into that theory, to now represent Donna Adelson. And I maintained throughout the past months that I've been analyzing this trial that it's not a good idea. Dan Rashbaum should not be actually representing. Now, if Donna Adelson likes Dan Rashbaum, she can certainly keep him in the loop, and she can ask her new attorney, whether it's Alex Morris or somebody else, to keep Dan Rashbaum apprised and hear his ideas and let him watch the trial and kind of be whispering into their ears. But to actually represent Donna Adelson, I thought was not a good idea. And now we're just seeing some of this play out. But aside from the tactical reasons why not to represent Donna Adelson, now we're having an actual conflict problem. So again, we just started the motion. So let's continue. We'll take it step by step. In the instant case, the state filed, meaning in the case of Donna Adelson, the state filed an amended answer to demand for discovery. Here's the state letting the defense know what they're going to be introducing at trial, what witnesses are going to be calling, etc. And they filed this on July 11th, 2024, which is also going to give reason why the judge would say, why did you wait? If you got this information on July 11th, 2024, why are you waiting literally the eve before trial to bring this motion? Continuing, the document listed an additional prosecution witnesses, one of whom was Mr. Adelson, meaning they filed on July 11th, 2024. The state let everybody know we may be calling Charlie Adelson. Now, it doesn't mean that they're actually going to call Charlie Adelson. And in fact, today during the hearing, Georgia Kaufman said that she listed him just as a rebuttal witness, not as a witness that they're going to be calling in their case in chief. Their presentation of the evidence, they're not going to be calling Charlie Adelson, but maybe if they need to rebut something that the defense brings out, they may call Charlie Adelson. Nevertheless, he's on a witness list. So there's definitely the potential that he's going to be called. So you have to deal with it. You can't have a trial and say, well, let's just hope he doesn't get called, because if he does eventually get called and now there's a real conflict, there's a real problem. What are you going to do in the middle of a trial like that? So we got to take care of these issues before. Definitely. No question. This is not something that you can just kick down the can and say, well, let's deal with it when it arises. Like a lot of times judges will do that, but it's not when there's a conflict issue. It's when it's an issue where we're not sure what the ruling on the evidence is going to be. It depends how the evidence comes in. Then the judge will defer ruling. But in this situation where there could be a conflict, he has to make a ruling right now. We can't have a trial and then in the middle say, well, I guess there's a conflict now, start over. We're not going to do that. So Charlie Adelson is now listed as a witness. The trial, this is continuing in the motion, the trial in Mrs. Adelson's case, Donna Adelson's case, is scheduled to begin the week of September 16th, 2024. That's right now. Mr. Rashbaum, as we know, is one of the defense attorneys who will be representing Mrs. Adelson during her upcoming trial. Yes, Dan Rashbaum is one of the attorneys representing Donna. All right, let's move on. So then they quote the Sixth Amendment. The Sixth Amendment, as we know, gives every individual, every defendant, the right to effective assistance of counsel. And not only that, but the assistance of counsel that you get to choose. You're allowed to choose your counsel if you can afford it. Of course, you can't afford it, then you'll be appointed one. But you get to initially choose your counsel, but you don't always get to choose the counsel. For example, if there's a conflict, that's also straight in the case law. They didn't bring this cite, but this is also true that in the case law, you're not allowed to choose an attorney who is going to be some sort of conflict, and the scales of justice would require in that case that we need to have a fair trial. So you can't just pick whatever attorney you want if you're not going to have a fair trial. So your right to choose your counsel is not absolute. Nevertheless, you do have the Sixth Amendment right to choose counsel. And also on top of that, embodied in the Sixth Amendment is also the fact that you're able to have an attorney-client privilege. What information I share with my attorney is completely privileged. He's not allowed, the attorney is not allowed to use that information, share that information, and use it definitely to my adverse interests. So you can't use that against me in any way. So we're going to get into that. Now, there's also a rule of professional conduct. So as we've spoken about a lot of times, every single jurisdiction has their own separate rules of professional conduct. They're very, very similar to each other, almost exactly the same. But each jurisdiction has their own rules of professional conduct, which is like ethical rules that lawyers have to follow. So they also cite, and this is Charlie Adelson's attorneys, they also cite Rule 4.19 of the rules regulating the Florida bar. And this is the rule that talks about the conflict of interest. And here it says, a lawyer who has formally represented a client in a matter must not afterwards. So you have a client, you represented them. Now, what are you allowed to do with that after you're done with your representation? Well, here we go. Number one, a lawyer who has formally represented a client in the matter must not afterwards represent another person in the same or a substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives informed consent. So here you represented client A. Now you want to represent client B. Client B's interest in this substantially related matter is adverse to client A, meaning they have opposite interests, client A and client B. So you represented client A. Now you want to represent client B, and it's a substantially related matter, and their interests are opposite each other. You're not allowed to do that unless your former client gives consent. So your former client has to waive that conflict. Not the new client. New client also may have to, but definitely the first client, who your first client was, they have to waive the conflict. So in this case, who would that be? Charlie Adelson. Now, we've heard a lot of times on the record where the judge would ask Donna Adelson, do you understand the conflict? Do you waive the conflict? And yeah, we've spoken about that. And whether that was a good idea by Dan Rashbaum to represent Donna Adelson, I've spoken very clearly. I don't think it was a good idea. I think it was a poor judgment, and I don't think it should have been done. But nevertheless, that was definitely asked of Donna Adelson by the judge a number of times. Do you understand the conflict, and are you willing to waive the conflict? But that was never done with Charlie Adelson. Charlie Adelson was the former client of Dan Rashbaum, and that's what the rules say. You got to get a waiver from the former client. All right, now let's move on. B. So there's another part of this rule of professional conduct, that a lawyer, again, who has formally represented a client in a matter must not afterwards use information relating to the representation to the disadvantage of the former client. So, can I use information that I've learned from my first client and now use that to help my second client, but that will now also disadvantage my first client? I'm not allowed to do that. I'm not allowed to use any information that I learned from my first client to his disadvantage. Okay, now that's where this is really going to come into play here. But first, we have to understand a case. There's a case called Kolker versus State. And in Kolker versus State, what happened there was a number of partners, and they were all being prosecuted under RICO. Okay, exactly what the charge was, it doesn't matter that much. But they had a number of different partners, Kolker and Kruger. Okay, so you got Kolker and Kruger. Kolker and Kruger both had one attorney. There was one attorney who was representing the business in a number of different matters. In fact, he had an office on site. So this was a hired counsel. He was retained. He's probably put on salary, and he was their attorney that they would always turn to and talk to about whatever they needed to talk about. So very clearly, Kolker and Kruger both had an attorney. Now, Kolker and Kruger are being prosecuted under RICO, and Kolker is represented by this attorney. Okay, so just Kolker is, not Kruger. So again, before they were prosecuted, this attorney would represent both Kolker and Kruger. Now, in this RICO action, this attorney is representing only Kolker. But Kruger is going to testify against Kolker. All right, now you see the problem here? What's the problem? The problem is that this attorney knows a lot of information about Kruger. He definitely knows a lot of information because he used to be their attorney for many, many years. So he used to represent Kruger. So even though now he's only representing Kolker, he's not representing Kruger. But since Kruger is going to testify against Kolker, and this attorney knows so much good information that he can cross-examine Kruger on from the information that he learned before in their previous relationship as an attorney-client, he's not allowed to represent Kolker anymore. That's what that case stands for. So when you have this attorney who just wants to represent Kolker now, because he represented Kruger earlier, and now Kruger is going to be a witness, he cannot cross-examine Kruger. It's not fair because he knows all of the goodies. He's got all the goods on Kruger, and he's going to be able to destroy him cross-examination only because he knows all of his deep, darkest secrets, because they used to have an attorney-client privilege relationship. So that's what that case stands for. And that almost mirrors exactly what this case is. You have Dan Rashbaum, who initially represented Charlie Adelson. Now he's representing Donna Adelson, and Charlie Adelson is going to testify against Donna Adelson. Now, who's going to cross-examine him? If Dan Rashbaum now cross-examines Charlie Adelson, that's unfair because he knows so much more information about Charlie Adelson than anybody else. And he's going to be able to use that as fodder for cross-examination. So Charlie Adelson's attorneys are arguing that Dan Rashbaum cannot cross-examine Charlie Adelson. Not only that, they argue the following. Listen to this. Further, unless there is a finding by the court that Mrs. Adelson's defense team constructed an ethical wall with regard to Mr. Rashbaum's knowledge and information gleaned from his prior representation of Mr. Adelson, meaning Charlie Adelson, from the initiation of its representation of Mrs. Adelson, and I'll explain this in a second, in this same or substantially related matter, Mr. Adelson would assert that his privilege and the conflict of interest applies to the entire defense team. So not only are they looking to disqualify Dan Rashbaum from representing Donna Adelson and potentially cross-examining Charlie Adelson, but now they're looking for that conflict to spread to the entire defense team. Why? Because there's this concept where let's say I work in a firm of 100 attorneys. Let's just give an example. I don't have 100 attorneys, but let's say I work in a firm with 100 attorneys. There's bound to be a conflict at some point with one of my attorneys and one of the clients that I'm going to potentially represent, right? There's 100 different attorneys. We have a whole bunch of different clients. And at some point, there's going to be some sort of conflict. So what do we do in that situation? Well, one easy way is to say, well, turn away the business. And that's not fair. I want the business. So what I can do is I construct this ethical wall, which means that we're going to completely deny any sort of information from being able to be accessed by that attorney who has the conflict. So if there's a specific attorney, one of 100, that has a conflict, we're going to completely shut him out of anything to do with this client. He's not going to have access to the files. He's not going to have any sort of information. That's this ethical wall. And we're not going to talk to him. He's not going to talk to us. He's going to work in his office on his files, and he's not going to have anything to do with this client because he has a conflict. So there is that concept where you are able to do that 100%. You're allowed to do that ethically and legally in a practice. So in this situation, if you have Dan Mashbaum, who represented at one point Charlie Adelson, and now he's representing Donna Adelson, and now you have this other attorney there, Alex Morris, right? So if they constructed this ethical wall in which Dan Mashbaum was not going to share any information with Alex Morris about his previous representation of Charlie Adelson, then you can make the argument that Alex Morris should not be conflicted out of this problem. But if there hasn't been this ethical wall constructed, and Dan Mashbaum was sharing with Alex Morris all of the strategy and all the tactics and all the information that he learned from Charlie Adelson and all these secrets that he knows because of attorney-client privilege, and he was sharing that with Alex Morris to help prepare, or whatever he's learned from the Charlie Adelson trial, if he was sharing some of that information with Alex Morris, well, then they're arguing, Charlie Adelson's team is arguing, that Alex Morris now is also going to be considered conflicted out, and he should not be able to represent Donna Adelson in this trial. So that was their first moving paper, their first motion, their moving papers, and they're arguing, sorry, Donna Adelson doesn't have any attorneys right now. If you're going to call Charlie Adelson as a witness. Now, of course, the prosecution could get up and say, you know what? We're just not going to call Charlie Adelson. We won't call him as a witness. We won't call him as a rebuttal witness. And that can take care of this problem, potentially can take care of this problem. But the prosecution doesn't want to do that. They don't want to shut down. Maybe they need Charlie Adelson to establish something. So they don't want to, handcuff themselves. So if Charlie Adelson is going to testify, what are they going to do? You can't have Dan Mashbaum, and according to these papers, if you don't have an ethical wall, then Alex Morris can't cross-examine him either. So therefore, the whole defense team is out the window, and now Donna Adelson has to go hit the street and look for more attorneys who have to get caught up to speed, and there's going to be months and months and months and months of delay now because now these new attorneys are going to have to get caught up to speed. So that is the question, and this is their motion literally a day before the trial is supposed to begin. Well, what is Donna Adelson's response? So the response is the following, a very small response, but this is what their suggestion is. Their suggestion is, again, this is Alex Morris. His suggestion is that, first of all, they do say there was an ethical wall. Okay, defense counsel believes that an ethical wall was created where Morris was not tainted or contaminated by information from Mashbaum. Third-party counsel has been secured specifically for the purpose of examining Mr. Adelson should the need arise. So now what they said is like this. Number one, there's an ethical wall. Number two, there was an ethical wall. Number two, we actually retained a completely third-party counsel, an independent, totally new attorney, maybe brother counsel even. They got a new attorney that has nothing to do with anything about the case up until this point. And that person's job is going to be solely for the purpose of cross-examining Charlie Adelson. And that person obviously has no information about Charlie Adelson. There was never any attorney-client relationship there. And this other person, this other attorney, this third-party counsel is going to be the one who's going to cross-examine Charlie Adelson should the need arise. And now, this is what they finish off with. The undersigned has conferred with Mr. Offerman, who is Charlie Adelson's counsel, as well as Mrs. Koppelman. The aforementioned proposal appears to resolve Mr. Offerman's concern. Counsel does not believe Mrs. Koppelman has an objection to the proposed remedy. So it seems like, okay, we got a great idea here. Prosecutors agrees. We're on board. The defense is on board. We're going to bring in this third party counsel, and they're going to be the one that if the need arises, if Charlie Adelson is ever called as a rebuttal witness, he's going to come in and cross-examine Charlie Adelson, and that's it. Well, there was a response to this response. So a reply to this response. And this is what they say in response. They say, here's the problem. It's a nice idea, but there is a straight out footnote that says in that case of Kolker versus State, the footnote, and they don't say it as a footnote, but it is a footnote. I looked it up, something that we do on this channel, that we actually look up the cases. So there's a footnote there, and the footnote says the following. Petitioner has argued, and you can see whether this sounds familiar at all. Petitioner has argued that any actual or potential conflict could be avoided by having substitute counsel conduct a cross-examination of Marks's former client. In that case, Marks was the attorney. So exactly the same suggestion was brought up in Kolker. Substitute counsel can conduct the cross-examination of that client, of Kruger. We disagree, and the court is saying we disagree with that. That's not a good idea. The conflict arises from the past relationship and cannot be avoided by sectioning off portions of the trial. Now, they don't really explain why it's not a good idea. They just say that statement that we just read. The conflict arises from the past relationship and cannot be avoided by sectioning off portions of the trial. Why? I'm not sure. To be honest with you, there's no further explanation. Such an unwieldy procedure could only further cloud the glass. The potential for conflict would remain, as would the appearance of impropriety. So, look, whether you understand the reasoning or not, but this exact suggestion was brought up in that case of Kolker versus State, and the court rejected it. So where do we find ourselves right now? Well, what we find ourselves right now is that the judge said, okay, the judge asked Donna Adelson if she would like to consult with a counsel who is not conflicted in order to decide whether she wants to actually waive the conflict, even though she's already waived it 3 times. So the judge said, do you want to speak with an independent counsel who's not representing you just about this issue, which is also very commonly done. You want to consult with independent counsel about the counsel that you're having right now with another attorney, right? No shortage of attorneys out there. So she said yes. So the judge said, okay, we're going to reconvene in about less than an hour from as I'm recording this video. So I'm not sure we're going to get this, but we will see what's going to happen with the judge and this issue at 1:15. I think that's what he said. They're going to come back at 1:15 and discuss this issue. But this is the issue. And the problem is that the suggestion that Dan Rashbaum and Alex Morris made is rejected by the court. So therefore, we're going to be at a real interesting position. And we will see what's going to happen with the Donna Adelson case, whether it's actually going to go forward now or not. So another twist and turn in the Adelson case. Well, that's going to be it for now. Thank you all for watching. And if you haven't yet, please subscribe, like, and we will see you next time.